Lawyers will now act as state agents after they yielded to mounting pressure to report suspicious transactions by their clients to the government agency Financial Reporting Center (FRC) to scale up efforts against money laundering in Kenya. This requirement was a precondition outlined by the International Monetary Fund (IMF), requiring Kenya to fulfill to continue accessing a 334 billion shillings from the foreigners-controlled Bretton Woods institution. Effectively, the pact between the Law Society of Kenya (LSK) and FRC ends a stalemate that had tested one of the stringent conditions. Yesterday, while appearing before the National Assembly's Finance and National Planning Committee, FRC Director General Saitoti Olemaika told the National Assembly that FRC signed consent with the LSK to withdraw a case which has blocked the implementation of a new law that compels lawyers and their staff to disclose suspicious financial deals involving their clients. The lawyers moved to court through Nairobi-based lawyer Omwanza Ombati, arguing the changes to the act were harmful to practicing advocates. In 2019, the National Assembly approved amendments to the Proceeds of Crime and Anti-Money Laundering Act to compel lawyers to start disclosing suspicious financial deals involving their clients. Saitoti said, "We have reached an agreement with the LSK that it shall be a self-regulatory organ and that lawyers will report on proceeds of crime and anti-money laundering." The lawyers had raised an issue with the requirement that they report on their clients. They said, "This goes against client-advocate confidentiality, but we have agreed in principle that the LSK will be the regulator." The Assembly's Finance and National Planning Committee is currently conducting public participation in the Anti-Money Laundering and Combating of Terrorism Financing Bill 2023. Section 2 of C and Section 14 of B of the Proceeds of Crime and Anti-Money Laundering Act make the advocates and their employees, including accountants, clerks and cleaners, reporting agents of the FRC. Saitoti says they'll be depositing the consent agreement in court on Friday. The consent has been signed by the FRC Eric Theuri, the president of the LSK, and Attorney General Justin Muturi. The Proceeds of Crime and Anti-Money Laundering Bill 2023 seeks to amend Section 36 of the Principal Act to ensure that the LSK regulate, supervise and enforce compliance for anti-money laundering (AML), combating the financing of terrorism (CFT), and countering proliferation financing (CPF) for lawyers, notaries and other legal professionals. Currently, LSK lacks powers to undertake supervision of its members as far as combating money laundering and terrorism financing is concerned. The amendment bill reads in part, "The proposed amendment seeks to clothe the LSK with the supervisory powers as a single resolution board when having oversight over its members for anti-money laundering and combating financing of terrorism purposes." The amendments give the LSK powers to conduct an on-site inspection, compel the production of any document or information it may require for the purpose of discharging its supervisory mandate, and impose monetary, civil or administrative sanctions for violations related to AML/CFT/CPF purposes. The LSK will also be required to cooperate and share information with other agencies. The Central Bank of Kenya (CBK) has backed the proposed changes to the law, arguing that Kenya stands the risk of being placed on the Financial Action Task Force (FATF) grey list if it does not substantially address deficiencies, including legal reforms, by October 2023. CBK Governor Kamau Thuge told the committee chaired by Ainakoi MP Benjamin Langat that we risk a public statement being issued by FATF on Kenya's strategic AML/CFT/CPF deficiencies. This will result in a negative impact on international trade, negative impact on international transactions, and termination of banking relationships with international banks due to high AML/CFT/CPF compliance costs.
So that group, they always now go and evaluate other countries' anti-money laundering and financing of terrorism and also proliferation financing, and indeed that mutual evaluation report is actually the basis for why we are amending our anti-money laundering regime. it's kind of neighbors taking care of one another and judging whether their anti-money laundering regime is in line with the international standards.
The governor noted that failure to amend the act will create difficulties in establishing correspondent banking relations and delays in processing international transactions. Thuge also noted that the proposed law seeks to amend the CBK Act, the Banking Act, the Microfinance Act, and the National Payment System Act, adding that CBK does not have the legal mandate to supervise institutions and enforce compliance of financial institutions for AML/CFT purposes. Thuge says supervisors of financial institutions have no powers to issue guidelines on AML/CFT. CBK does not have the power to share AML/CFT supervisory information with other supervisors. There are weaknesses in requirements for beneficial ownerships during licensing and vetting of significant shareholders in financial institutions. Further, he decried that CBK does not have powers to compel financial institutions to produce documents for purposes of AML/CFT supervision. On his part, Capital Markets Authority CMA Chief Executive Officer CEO Wycliffe Shamir said the authority supports the proposed changes to give regulators the power to monitor anti-money laundering activities. In 2021-2022, Kenya underwent its second anti-money laundering and counter-terrorist financing mutual evaluation, a peer review assessment by the Eastern and Southern Africa Anti-Money Laundering Group, which found a number of deficiencies and recommended ways to strengthen the country's AML/CFT/CPF regime.